But occasionally one will make me go, huh. Oh, wait, we just did that episode. Occasionally one will make me go, hey, what was that?
Help me with hip-hop. Let's get it right. Protect your patience. Day and night. Donna and David, the experts on your side. Help me with hip-hop. Let's get it right.
All right, today we're going to be talking about reasonable security that holds up in court. Man, because that's always the question. Like, what is reasonable?
Yeah.
So
That's what I always tell people is, look, I'm going to tell you to do things that if you had to ask me to testify, I wouldn't mind telling them, this is, I would feel positive about saying this is reasonable for you to do.
Yeah.
Otherwise, I'm not going to say it.
Right. But you're explaining to a lot of unreasonable people about the reasonable things you're doing.
That's right.
So we'll get into that because we've got some interesting take on a new bill, I guess is what it is.
No, it's a law. It's been
already
signed
a
into law. Yeah.
Okay, cool. And this is in Oklahoma. And we'll talk about that. But first, let's talk about something that was unreasonable. This is one of those what the heck moments. We saw an article I think it was last week, and we couldn't get it into the episode last week because we had too much already.
I know. That came in right after the end.
Yeah, and this is just one of them. We had to leave some other ones out. Like the nurse that was snooping for 5 years before she got caught. We hadn't even talked about that one yet.
Yeah.
So this one, okay. Nurse live streams her MedPass rounds on TikTok and uses her teeth to open the meds.
Yeah.
Among other things.
Yeah. So, this article came from nurse.org. So, this was a nurse's perspective on a nurse's behavior. So I felt pretty positive about us, discussing what they shared there. But yeah, it was an ethics debate in so many ways. Yeah. So Yaz live streamed on TikTok doing her MedPass in a nursing home. And the number of times that there are people that are just, they're all about doing something on social media, and these elderly patients are abused by them. And it makes me so angry. And I know how they are when they have Alzheimer's and other kinds of dementia. Trust me, went through it with my mother. But that doesn't warrant putting them on social media and belittling them and treating them improperly. And we'll just leave it at that. So at least in this case, it wasn't that. So I'm glad to say that. I don't know that I could get through a discussion about some of these ones that are mistreating the patients. But this was, I'm going to show you what I do in my job, I guess. I don't know.
Yeah.
It's just walking along, doing her chatting live stream. So the camera apparently was only on her. And she's going around talking to the patients and saying, here's your meds and blah, blah, blah.
Yeah.
I'm like, But then when people started lighting up going, you need to, you're going to lose your license, you're violating HIPAA. And she was like, just relax. Mm-hmm. And how did you feel when you read this part? Because this is what we hear all the time. If you see some patient information, just holla, she said, laughing off the concerns. And I'm screaming, holla! Y'all should have all been hitting holla.
That's the problem. There were people hollering.
But in her mind, she wasn't exposing patient information. So there is step one of many problems.
Yeah, but the people that were trying to tell her that, you mentioned they were telling her she's violating HIPAA and all that. She blocked them.
Yeah.
And then mocked them. She blocked and mocked. Apparently that's a thing. But just it's the whole. We talked about this one time before where somebody did something on social media and it's not real life. It's just Facebook. Well, in this case, it was TikTok. Now, she didn't say it's not real life, but it was just like, chill out. Nobody's showing patient information. I'm like, well, you don't understand what patient information is then.
I know. Yeah. And telling them to relax,
Yeah.
Relax. Yeah. Holla. And I was like,
yeah. That's like when you walk in somewhere and you're like, we all just need to calm down. That never works.
No. But it was that moment where she should have really grasped instead of, she was clearly in a mindset of, I'm cool. I got this, I'm going to get some clicks and links and whatever she was worried about getting. But I did like the quote that she said that something, I had no idea. You go to bed and then you just wake up and it's gone viral.
Yeah.
You should assume that everything you do may be seen by the entire internet, number one, and number two, can never be removed, because those are both true.
Yeah. I mean, as you pointed out, her online cred may have, got a big boost. However, her professional cred probably tanked.
Yeah. Because she was officially suspended from her job.
Mm-hmm.
Pitting an investigation, but she has stated online that her job was already listed to be filled. So she's feeling pretty confident that, I'm sure the policy says up to and including termination, which I also hate. Maybe she knows she's gone too far.
I would hope so, even though I don't really like what she said about it in her update.
Well, and also the nurses licensing board is doing an investigation of her, in addition to the nursing home where she worked, and each of them say they had over 50 complaints called in.
Ooh, Lord.
Yeah. So she did try to, she made the point of saying, I woke up and was all over the internet with thousands of comments holding me accountable. Okay. She didn't say how bad she felt.
No, she didn't. But she did make nurses feel, she made nurses look bad, like just in general. And, here's an update on her TikTok. It was my understanding. She wrote this: I'm well aware of how extreme and severe my actions were. You do things and don't think about it. You don't think it will go viral or even be seen, which, okay, I have a little problem with that comment. But then she goes on, I woke up, it was all over the internet, thousands of comments holding me accountable. She expressed gratitude for the feedback, and this is from the article, and described her experience as a hard lesson learned, hoping her story can serve as a cautionary example for others. And I quote, be mindful of the content you put out, whether you're a creator or a student, she urged. So it's, to your point, like nowhere did she say, like, I shouldn't have done this and I'm sorry for doing this and I violated people's privacies and rights and all that. She's like,
yeah, or I apologize to all the patients. Nothing.
Yeah, nothing. Yeah. I'm well aware of how extreme and severe the actions were. Okay. At what point were you aware of that? And,
Yeah.
you don't think, here's the thing I didn't like. You do things and don't think it will go viral or even be seen. You shouldn't have done it in the first place.
If you didn't want it to be seen.
Yeah, it's I'm putting this on social media expecting it not to be seen. Come on now.
Yeah.
Wrong.
Wrong.
Yeah, but then didn't she do a GoFundMe too or something like that? Which is what the crap.
That's the people who I can't believe she's getting fired. Okay.
Yeah.
We're not going to go into that part of it. Let's don't even go. I don't think either one of us want to go down that rabbit hole. The soapbox will be drug out and stomped on and all that kind of stuff. But anyway. But I did notice Brandy Pinkerton, who is the nurse who posted the article and the updates and stuff. And I like that one of her headings is HIPAA isn't optional. We agree with that. Now, she did include some, maybe we'll call it outdated, more likely inaccurate information about fines and penalties. And she didn't mention that people they could even be criminally prosecuted for violating HIPAA. So, but she did make a point of saying, it's serious. Patient privacy is one of the things that we need for trust. But then she said something that went into a section of conversation, and it was concerning, and you want to say, how could this be? But the bottom line is she's saying it, so it's fairly true, more than likely. The truth is, a lot of us never got clear guidance on the boundaries before stepping into the profession. A 2024 Journal of Nursing Education study found that only 62% of nursing programs fully cover social media boundaries. That means plenty of new nurses are entering the field unsure of what's okay and what could seriously risk their license or a patient's privacy. And she did talk about how it was not clear, it was blurry. And her point was they tell us to use social media to discuss things and to learn things, which if they are, then that would be where the failure is, because they're not telling them how to do that. But it just drives home the importance of doing proper training.
Yeah, and constant, not once a year, constant.
Well, and just simply telling them what the law says does not provide training.
No. But fortunately for us, we now have a training moment.
I know. It's all a learning moment. And she, Yaz did say that she hopes that people can learn from her hard lesson learned, so she wants people to learn from it. So I encourage people to use this moment as a teaching moment because of that, but also to learn from it as, compliance officers and privacy officers and people that are in management responsible for these things, to realize whether we like it or not, they don't seem to understand those boundaries. Mm-hmm. And I mean, here's one of the things I think, you got a twofold problem is they don't understand the boundaries of social media, but on top of that, they think they understand the boundaries of social media.
Right.
Because she's like, I'm not showing patient information. So she truly believes she, understood it. And we see that all the time. This isn't real. It's Facebook. Or I didn't say their name. Somebody else did. We've seen these over and over on social media. And so whether we like it or not, the message needs to be changed or reiterated or delivered more often or something to say, I think we should start saying, look, unless you feel you are qualified to legally, so let's start with legally, de-identify a database of patient information so that it'll stand up in court. If you think you're qualified to do that, then come to us. We need you to work in the compliance office. If not, then you shouldn't mention anything, even confirming nothing, because that could be exposing patient information. And there's the line. There's the line. Say nothing, share nothing, confirm nothing, unless it falls within your job duties and it's part of your standard policies and procedures. So.
Yep. Well, one thing I will say, and just to add to the compliance officers and stuff, is if she has a defense at all, it is that there was a failure to train, and that falls squarely on the shoulders of the organization. So organizations, you have to do the training. You can't be mad, and you might not even be able to get away with firing somebody without some repercussions if you're not training them otherwise.
Well, the privacy wasn't the only part of it. The other part was opening a medication with her teeth, which is insane, and noticing that she gave the wrong medication. She made a mistake, and it was a timing thing. Thankfully, it wasn't something life-threatening, but she did make a mistake and broadcast that and acted like that was no big deal. So those two things is, you can't mitigate those with no, you should not be opening medication with your teeth. We won't need. I know that.
Yeah, but it's. I'm always interested to know, where did you learn the behavior? Like, is that something that she's seen other people do, or you see what I'm saying? Like, are you the absolute worst person that works there, or are you just one of the many people and you're just showing the behaviors you learn from other people?
And that's a very, very good question. And I think that the organization should be asking it. And we also are very well aware of senior facilities and nursing homes not being the best at doing this in the first place.
Yep.
So.
All right. Well, now that we talked about a lot of unreasonable things, let's jump into reasonable security that you can testify in court.
Yes. This was, we talk about the state laws are just constant. They're coming, they're going, they propose them, but they don't pass. They, all this stuff. So we've gotten to where we just can't keep up with what's there and what the requirements are. And, I'm pretty busy with HIPAA. Ain't nobody got time for state law in my world. But I mean, the bottom line is there are state breach notification requirements, and almost all of them do have some sort of exemption if you are a HIPAA entity that is required to make notification. So you do have that. So often it's just understanding what your state requires. Do you need to notify them in addition to HHS? And what if it's data that's not considered PHI? It falls outside of HIPAA. What are you supposed to do? So usually that's really all you have to know. There are some that we know are a bit more complicated that you've got to sort through. But occasionally one will make me go, huh. Oh, wait, we just did that episode. Occasionally one will make me go, hey, what was that? What did I just back up? That was flying past me on my feed. And this is Oklahoma made an update. It's an updated version. They already had one for a breach notification law, data breach notification law. And these changes, they passed, they've been signed by the governor, they go into effect January 1st. So, it's not theoretical that this could happen. This has been signed into law. And that's why it kind of got my attention, because I don't know that I've seen this. It could have happened. It just may not have gone past me in a way that I was able to go, hey, what was that? But this one, so first, just some general information, what their notification was. If you're in a HIPAA entity or, financial institution where you already have to deal with breach notifications, you're exempt. If the notification is if there are less than 500 people, which I would bet that there's a lot of 499 people involved. And you don't have to notify. I think credit bureaus, because they got so much data, they gave them a limit. Anything above 1,000, they have to notify. And I'm like, I don't know why. But so here's what it states. Entities that must comply. If you don't meet one of those exceptions, it's corporations, business trusts, estates, partnerships, limited liability partnerships, limited liability companies, associations, organizations, joint ventures, governments, governmental subdivision, agencies, instrumentalities, or any other legal entity, whether for profit or not for profit. So pretty much, if you're not excluded, you're included.
Yeah. So maybe not a sole proprietorship individual. I don't.
I wouldn't try it. A legal entity.
Yeah, that's true. That's true. Yeah.
So it just depends on your scenarios. But again, that would be one of those things where it's like, okay, yeah, I need a lawyer to figure out whether I can get out of this. But it's always been there where you have like 60 days to do these notifications, and it tells you stuff. And so what they, you have to send these notifications, emails, basically the same concepts as HIPAA. We don't need to go deep into those. That's not really what got my attention. But what they added that did get my attention is in the section where it talked about civil money penalties up to $150,000. So if basically they catch you covering it up and you didn't notify, or you didn't notify within the X number of days or whatever, they could fine you for up to $150,000. The state's attorney general's office somewhere in there is supposed to investigate, blah, 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 right? And we now are seeing those cover-ups come out, and I'm having to advise in a few cases on, well, we acquired so-and-so, and now that we've acquired them and we're way down this path, it appears there may have been a data breach that was not reported. And I'm like, I would like out of this. I do not want to participate. It's a mess. But what this law said is they added a thing after this, and here's the part, is an individual or entity that uses reasonable safeguards and provides the notice required. So that's important. You still have to comply with the law. You can use this as an affirmative defense in a civil action filed under the Notification Act. So all of these class action lawsuits, that we always say they come out within days. So you could then say, look, it happened, but you can't hold me responsible is basically what an affirmative defense is. My bad, but that's it. And then it says it's an individual or entity that fails to use reasonable safeguards but does provide the notice shall be subject to the civil money penalty of this section, but subject to actual damages, civil money penalty limits of $75,000, right? So if you don't do reasonable safeguards, it sets a limit if you do the notification. So they're trying to say, look, if you at least follow the law, we're going to
give you half off.
I know, right? So you don't even try to follow the law, $150,000. You at least notify $75,000. But you notify and show that you have reasonable safeguards in place when it happened. And now you can say, I apologize, but I am a victim, which is what I have always said is you're a victim if you have done everything reasonable to prevent this from occurring and it still happens. Because we know it is not possible to be 100% sure. So then I said, whoa. You can protect yourself from lawsuits if you can prove, and of course this is with any if I can't prove it, then it didn't happen.
Yep.
Which, as I always say, really only matters. And criminal court.
Yeah.
Yeah. Anyway, so then I went looking for reasonable safeguards. And will you go ahead and share what it legally says and tell me what your first thought was when you read this?
So the reasonable safeguards means policies and procedures that ensure personal information is secure, taking into consideration the entity's size and the type and the amount of personal information. The term includes, but is not limited to, conducting risk assessments, implementing technical and physical layered defenses. Oh, I like that. Employee training on handling personal information and establishing an incident response plan. All right. So my first thoughts are, anytime something says including but not limited to, that's already like, okay, this is like the bare minimum that you should be doing. Not, and I don't mean the bare minimum to pass. It's like the bare minimum. So you got the risk assessment, you got the implementing the technical and physical layered defenses. So there you go. It's not like a one, you can't buy this one thing to do it. Interestingly, it didn't jump into the administrative part of it, which I see in HIPAA as well as like FTC safeguards and some of these other ones, even though it mentions some aspects of it. But training,
but doesn't it like risk assessments, training, all of that is administrative safeguards? Maybe they just didn't name it.
Yeah, that's possible as well. And but yeah, it's guess what? HIPAA for everybody. But it also sounds a heck of a lot like the reasonable safeguards that we've been talking about under HICCUP, which is recognized security practices.
Yeah, and these are all things that are in HIPAA, should be doing them, and they could basically. We've always said that it doesn't really matter if you're not in healthcare. You could take HICCUP and the 3 different sizes and use them.
Yeah,
the CIS controls do it based on size as well. I don't know if any of the others are really good at doing it based on size, but they do. Anyway, they can basically take HICCUP, adapt it, pick their size, adapt accordingly, and then be able to prove it, which then takes us into recognized security practices.
Mm-hmm.
And so if they could then do all of these things, regardless of the size, type of business, all of these, and they're saying, look, if you can do this, then you get this as an affirmative defense. Why is it people can't do the same thing when HIPAA's been telling them they're supposed to do it for decades, literally decades?
Yeah. I mean, we've been saying this for years that whether you're in healthcare or not, you will end up having to do something that looks very much like HIPAA. And we're seeing it every day now, starting to get rolled out. Some of them had different things they call it, just like in this one. It's called something different. It would be great if there was just this one privacy rule to rule them all, but there's not. And
we're nowhere near that. Yeah.
No, and I don't know that we'll ever see that. And notifications are all over the place, and some are 30 days, some 60 days. Some people are talking about less than less than 30 days. So those are the things that's harder to navigate. Like what actually do I fall under? And you and I talked about how all 50 states have breach notification laws. So you have federal breach notification, state breach notification. It can get hairy really quickly, which is why it's like, just do the reasonable thing and follow the safeguards and have your evidence. It's so much easier than dealing with the fallout. It's so much cheaper than dealing with the fallout.
Yeah, in the long run, it definitely is. And it protects your reputation, and it gives you the ability to bounce back, and continue your business as usual, which is hard to do. There are groups that still to this day, you mention their names and everybody like, oh yeah, the data breach ones. And I'm like, the big one.
Would they be in Georgia? Would they be in Georgia?
Yeah. Indeed. But yet I digress. And now there's going to be time because the state AG office, whoever gets identified as the one who gets to make these decisions, is going to have to come out and say, well, this is the kind of proof we're looking for, which is, what OCR has done with recognized security practices. But I had a thought of something interesting, that if you are a healthcare entity in Oklahoma, and this law doesn't, you're exempt from doing the notifications, but you're doing the notifications under HIPAA, could you then come back and say, hey, I get the affirmative defense if I can show recognized security practices or at least reasonable standards? So that's going to become a question at some point, to then be able to step away from some of these, those class action suits. No one makes any money. No one gets real protections other than pay for identity theft protection. The only people that make money are the lawyers. And
well, I got my $3.63.
I know, right? It's like sometimes it costs more to apply for whatever it is that you get as a member of the class. I think I've at most ever gotten like $100 in one of those kind of deals.
I had one recently, and it was like, go online and fill out your form, and I went on, I don't remember how much it was. It said something like every person will get, it's like $11 or something. I go out, this form is like an hour long to fill out. I'm like, no, I'm not spending an hour to get $11.
I know, I'm losing money.
And then I had to pay taxes on the $11.
It's just more paperwork. So it's really not worth it most of the time. But I do think that it's going to be interesting to see the first time that attorneys try to do that. But the thing is you're not going to be able to do it unless you can prove that you were doing the reasonable safeguards. Now, one key difference between this and recognized security practices is it doesn't say you have to prove you were doing it 12 months before.
I was looking for that.
Yeah.
That's interesting.
So
you know what's going to happen. I just started it yesterday. Donna, can you backdate that?
Those calls. Will you backdate a security risk analysis? And no.
Yeah. So that might be something they have to revisit. Once people will figure out how to kind of get around that loophole, they may go, you know what, this we need to add a little bit more to this.
Yeah, but they've added this, which is good. And I like the affirmative defense fee, part of it. You could make that argument, and most attorneys would make it and make it successfully in any kind of class action suit if you could prove those things anyway.
Yeah. Well, that's just it. Like, okay, there's not a 12-month rule on this thing, but however, if I go to court, what can I prove? Can I prove that I did it, first of all, before the incident at all? Or maybe I did just do it a month before the incident, but if I've got all the proof that at least I did it before the incident, that's better than nothing.
Right. So it's going to start making a dent in some of these cases because, but again, it gets back to drawing that line. You are a victim of an attack, but do you warrant some of the accountability and responsibility because you didn't do anything to prevent it in the first place?
Yeah.
Or you didn't do reasonable things. They always talk about the insurance company wants to know, do you lock your car?
Yeah. I left my keys in the ignition.
Yeah. If you're going to leave your keys in the car, they're not going to be happy about trying to replace it if it's stolen, and it's that kind of stuff. So,
well, the thing I would caution everybody on is the whole including but not limited to, because I'm telling you, there are going to be people that come out and they're going to see where it says you have to have policies and practices, including but not limited to, and it's going to list these 4 things, And that's all they're going to do is those 4 things because that's what they saw in the list.
Yeah. And well, and you know, if you do a risk assessment and then you don't have technical and physical layered defenses or employee training, you know, that's kind of hard to do, to, you know, not do all of those pieces. But an incident response plan is one where we run into this all the time. Incident response plan. I will call David.
Or it's one document, you know, it's like, okay, well, are you planning on having one type of incident? I mean, it's kind of like at some point your incident response plan should splinter off a little bit, or, you know, these are the 3 things that are most likely to happen. Well, then have an incident response plan for each one. And it's not the whole incident response plan is not going to be different. It's going to differ at some point. It's going to splinter off and then probably come back at the end.
Right. Well, it's kind of like, you know, some parts of your incident response plan would be the same between some sort of email compromise, whatever type, and a ransomware attack. Yep. And a ransomware attack where they don't encrypt. They just steal the data and hold it for ransom. So your incident response plan is different across all of those, but there are portions that are the same. But you can't just have the same one with no acknowledgement that there's going to be differences there, and a plan for it.
This, you know, that's why we like making them modular. So you can just move things here and plug things here.
Yeah, plug this in, plug that in.
It's like making a soup. It's like get all the ingredients and see what you're going to throw into this one.
You know, it's like people that have to have a recipe, and if they don't have everything in the recipe, I can't make this. Now, there are certain things, you know, if it's some sort of recipe and you don't have the key ingredient, like, I don't know, a real Southern thing, green bean casserole, but you don't have any green beans, you're not going to make green bean casserole. However, you know, if you're missing one little piece of this or a little piece of that, and, you know, you're going to figure that out. You can figure that out. But I better have some green beans.
Yeah, you better.
You know, you never know when a funeral's coming.
We'll keep a green bean casserole in the freezer just for that.
Hey, that's some country church things, you know. This year you're making green bean casserole. Last year you made cream corn. So, and bonus for those of you who know exactly what I'm talking about, send us a message. I don't know that I'll give you anything, but I will give you a bonus. Attaboy, that you know exactly what I'm talking about. But
give you a green bean casserole recipe.
I know, right?
Taken right from the side of the French's dried onion can.
I know. You know that's absolutely right. And everybody will say, "This is my grandmother's recipe." Grandma got it off the can because it matches.
Yep.
No, they took it from her.
No, it's only 3 ingredients. I know. I made a many of them.
Life is good. Anyway.
Yep. All right. Well, that was a good conversation about things that are reasonable and unreasonable. So there you go. You should have a lot to talk about. Certainly run back to your folks and talk about this whole craziness on TikTok and make sure they're not doing it. We don't need any more things to talk about when it comes to social media. So make sure that is not happening. And kind of a little bonus there, if you are paying somebody to do your social media, anything around that, especially if they're coming in and recording and things like that, make sure they understand what they can and can't do. Yeah. That's a whole nother topic.
But David, everybody uses them.
I'll end on that. Thanks again, folks. Be sure to join us again next week. And remember, for Donna and myself, that HIPAA's not about compliance. It's about patient care.
You've been listening to the Help Me with HIPAA podcast, hosted by Donna Grindle and David Sims. The show created to help you with HIPAA. For more information or to ask us a question, visit our website at helpmewithhipaa.com. Neither Donna Grindle or David Sims are attorneys, and they do not offer binding legal advice concerning regulatory compliance. The information in this podcast should not be relied upon or construed as legal advice in any way. Consult your attorney for legal advice concerning compliance with HIPAA regulations.